Hi, this is Suman Dash Bhattamishra, Assistant Professor of Law at National Law University, Odisha, Cuttack, and today I am here to discuss a module on the law relating to dowry in India as part of your course in Substantive Criminal Law. Before we begin with the details of the topic, let me first introduce you to the idea of dowry. Of the many social problems that we face in India, the problem of dowry is probably the most unique. It is suggested that the roots of dowry in India date back to the later Vedic age of the Indian society, where the position of women had just started degenerating. Ever since, we are acquainted with the concept of dowry in India across various communities of the country. No matter how old the roots of this problem are, its impact remains the same even today, and maybe it has even got worse with time. The problem of dowry is not specific to any particular religion in India or to any particular community in the country. It is a problem which has affected all religions, regions and communities in some measure or the other. Now, as we go ahead, I think it will be pertinent on my part to lay down the objectives of this module. The objectives of this module are threefold. Firstly, to introduce students to the problem and concept of dowry, to inform them of the laws in India relating to dowry, and to discuss important case studies to trace judicial trends in this area. Now, to begin with, I would like to discuss with you the Dowry Prohibition Act of 1961, in which section 2(1) of the act defines the term dowry, and when read together with the explanations, it provides the following elements in the concept of dowry. First and foremost, the subject matter of dowry may be any property or valuable security. Such property or valuable security may be given or agreed to be given directly or indirectly by either party to the marriage or by parents of either party to the marriage. The transaction of property or valuable security must be in connection with the marriage and may be given at the time of marriage or before the time of marriage or after the marriage. Dower or mahar, which is a very important concept in Muslim law, at the time of nikah, which is given as a form of gift, is excluded from the denotation of the term dowry under the Dowry Prohibition Act 1961. Gifts or presents which are made to either party at the time of marriage in the form of jewelry, clothes, cash or other articles are also excluded from the purview of dowry under the legislation. Now, as we begin to understand the various elements of dowry, it will be pertinent for us to also look into the concept of valuable security or movable property. Now, when we say valuable security, what exactly is connoted by the term? Section 30 of the Indian Penal Code discusses the concept of valuable security, and in the IPC, valuable security is defined as any document which has the capacity of creating rights, extinguishing rights or altering or amending rights. Now, when we talk about property, because the definition of dowry, as we remember, includes in its connotation that it involves the exchange of valuable security or property. Such property may be movable in nature or it may also be immovable property for that matter. When we say movable property, we refer to things like cash, ornaments or artifacts or other such valuable things. But when we say immovable property, we refer to property which may be in the form of a land or a house, etc. So, all these things can come within the purview of dowry if they have been made as a consequence of an exchange at the time of marriage, and they have been in connection with the marriage, they have been either given or agreed to be given by either party to the marriage or by representatives of the party to the marriage. Now, Dowry Prohibition Act 1961 penalizes not only the taking of dowry, but it is important to notice that under section 3 of the Act, both the process of giving and taking of dowry has been penalized. Under section 4, the Act also states that any agreement for the giving and taking of dowry will be treated as void. Section 8 of the Act provides that offences under this Act will be non-cognizable, bailable and non-compoundable. A well-known case in this connection is the case of State of Andhra Pradesh versus Raj Gopal Asava and another. Now, in this case, the husband, brother-in-law and mother-in-law of the deceased were put on trial for suicidal death of the bride. In the trial court, there was sufficient evidence to show that demands for dowry had been made by the brother-in-law and the mother-in-law, whereas the husband's participation was put forth as only passive. Although all of them were held guilty under section 304B at the trial court, the High Court acquitted the three of them on the ground that there was no evidence to show that an agreement had been entered into for the payment of dowry, and therefore, since there was no agreement, the High Court had ruled that this cannot be a case of dowry. Now, if there is no dowry, the linkage between dowry and death has not been established. Obviously, it cannot also be a case of dowry death. Further, it was also held that demands made after the marriage would not qualify as dowry. On appeal, however, the Supreme Court held that the demand for dowry does not presuppose an agreement to the effect. This case was a landmark judgment of the Supreme Court in the field of dowry for various reasons. First of all, the issue of whether an agreement has to be formed for the purpose of defining the concept of dowry was a necessary proposition. So, here the Supreme Court ruled that an agreement is not a necessary portion or a necessary part of the concept of dowry. There may or may not have been an agreement to the effect, and one need not look or fish out for evidence in connection with this. And even in the absence of an agreement, a question of dowry may be answered in the affirmative. The court also observed that the purpose of amending section 4 of the Dowry Prohibition Act of 1961 was also to reiterate the fact that demand for dowry may be either direct or indirect, it may be active or it may be passive, and all such forms of demands for dowry have been covered under the relevant section of the Dowry Prohibition Act 1961. The interpretation of section 2 must also be made in the light of circumstances of every case. So, whether in an individual case an indirect demand for dowry or a direct demand for dowry can qualify as a dowry or as a concept of dowry within the purview of Dowry Prohibition Act of 1961 is a necessary factor for us to understand. Therefore, the claim of the respondents that a dowry can be said to have been demanded only when there is an agreement to the effect was not justified according to the Supreme Court and was also not held to be legitimate, which is also why such an interpretation was reversed by the Supreme Court. So, the High Court's consideration of a judgment which had been delivered as a situation of as not a situation of dowry death, because no question of dowry was there in the picture due to lack of an agreement, was reversed entirely by the Supreme Court in this case. Likewise, in the case of the Public Prosecutor High Court of Andhra Pradesh versus Nesse Jilara Sri Ramulu, two cases were referred by a division bench of the High Court of Andhra Pradesh for consideration by a full bench. The two cases referred were Ayala Rambabu versus State of Andhra Pradesh and Nunna Venkateswaralu versus State of Andhra Pradesh. The objective was to verify whether the points that were laid down in these cases were good in law.